Thank you so much, Chair Balboni, and thank you as well to Dean DeSias, to the Board of Trustees, and to New England Law Boston for this great honor. Thank you as well to Assistant Dean Jackie Pilgrim and Talia Rivera for all of their hard work in organizing this wonderful event. And thanks to all the distinguished guests, including current and retired colleagues from the state court system and those from the federal bench, and the faculty, students, alumni, and friends of New England Law for being here this evening. I especially want to thank my family and friends who are here tonight. As you heard, my father, Wayne Budd, who was a trustee and continues to be a trustee of New England Law for many years, my sister, Christy, who's visiting from Atlanta, my niece, Olivia, my husband, Bill Thompson, my mother-in-law, retired Judge Ann Thompson, who, you know, she's from the Federal District Court of New Jersey. What you don't know is that she was the first Black person and the first woman in the Federal District Court of New Jersey to be a Federal District Court judge. So, I also want to welcome and thank Walter Prince for being here, longtime New England Law outside counsel, and of course, my former law clerk and close friend, Mary Sheehan of Ropes and Gray. It's really a pleasure to be here with you. I've been to this event several times over the years, and knowing that you often have justices of the Supreme Court of the United States, I never dreamed that I would be up here speaking with you. Which reminds me of a funny story. Several years ago, many, many years ago, I was here at the New England Law Day dinner with my dad. As it happened, the scheduled speaker was supposed to fly in that evening. Some of you may have been here for this, I don't know, but what happened was the plane was not able to land in Boston in time for the event. And my father was asked to fill in 30 minutes before the dinner was to start. I said it was a funny story. I don't know that he would say that it was a funny story, but he ended up doing a great job, despite the fact that he had so little time to get ready. Lucky for me, I've had a little more time to prepare, so I'm hoping that I'll live up to the high standards that my dad has always set. You heard that I used to teach at New England Law. I taught legal writing under the program headed up at the time by longtime faculty member Daveline Cooper. I loved having the opportunity to work with the students. And what's been great is I've been able to watch the growth and success of some of the students that I had, including Adam Sisitsky, who was recently named as a Superior Court judge last fall. In more recent years, at the SJC, I've had the opportunity to work with many, many New England Law student interns who've been so helpful to me and to the court. This semester, I've had the benefit of the keen intellect of Linda McClellan, class of 24. There she is. Students, you all look fabulous, by the way. But while I have your attention, I have a few words of wisdom for you. Whether you're getting ready to graduate or just finishing up your first year of law school or somewhere in between, please keep this in mind. You're likely going to have the opportunity to do many, many things throughout your career. My advice to you is to seek out meaningful work, whatever that means to you. For many, it means doing something that makes a positive difference in the world. It may be in a public interest or government setting, or you may work on pro bono projects on the side. And speaking of pro bono projects, as you likely know, unlike defendants in criminal cases, litigants in most civil cases have no right to appointed counsel if they can't afford to hire a lawyer. If they're lucky, some of the litigants may obtain assistance through one of the terrific clinical programs that New England Law runs, or through some other law school programs. But our legal aid organizations only have enough lawyers to serve about half of the people who turn to them for assistance. And there just isn't enough pro bono lawyers or law school clinical programs to fill the gap. As a result, in certain areas, such as housing, consumer debt, and family law, there's a high percentage of cases that involve at least one unrepresented party. For these self-represented litigants who have no legal training, and for some whose English is not their first language, it can be a struggle to find the right words to articulate their claims and defenses in court. But you, dear students, do have specialized training that you can use to help others. So whatever else you decide to do, please make time for pro bono work. Our Code of Professional Conduct sets a voluntary goal of providing 25 hours of pro bono service annually. And if everyone commits to performing at least 25 hours of pro bono service, well, it'll go a long way towards the promise of justice for all. So, as you've heard, I've had the opportunity to do many things with my law degree over the course of my career. Some positions were more meaningful than others. It may go without saying that having the opportunity to be the chief of the oldest continuingly functioning appellate court in the Western Hemisphere is an honor of a lifetime. However, as you may know, the circumstances under which I became Chief Justice were very difficult. My predecessor, Ralph Gantz, died suddenly and unexpectedly in the fall of 2020, 6 months into the pandemic. It was a complete shock, and it was a devastating loss to the entire court system. The idea of filling his shoes was daunting, especially given how universally admired he was. I'm grateful, though, for what I was able to learn from him while he was our chief. And I especially appreciated his emphasis on racial and ethnic equity in the courts. It's an interest that I very much share. And because he made it a court-wide priority when he was chief, I haven't had to convince court leaders that diversity, equity, and inclusion, criminal justice reform, and access to justice must be prioritized. Instead, we've simply continued to build on the foundation that he laid. Let me give you just 2 examples. First, the SJC Standing Committee on Lawyer Well-Being, which was created thanks in large part to Chief Justice Gantz, conducted town hall-style Zoom meetings with several affinity bar associations beginning in the summer of 2020. Early in 2021, they released a report stating that attorneys from unrepresented groups said that they face scrutiny, unfair assumptions, and insults to their professional identity in court settings. As a Black woman, this report was not surprising to me. I've had firsthand experience of being underestimated, misidentified, or simply ignored in courthouses when I was a young lawyer. For example, once when I was in the courtroom, I approached the clerk and was mistaken for a defendant's girlfriend or family member and was told that only lawyers were allowed past the bar into the well of the courtroom. I know that many others have their own stories along these same lines. And candidly, I continue to have similar experiences when I'm not acting in my official capacity. So, I have a vested interest in ensuring that everyone who comes into our courts is treated with dignity and respect. So in response to that report, the trial court has developed a new court-wide anti-bias training program based on the work of Dr. Robert Livingston of the Harvard Kennedy School. I want to thank Trial Court Chief Justice Heidi Brieger and Court Administrator Tom Ambrosino, as well as their predecessors, Chief Justice Jeff Locke and Court Administrator John Baio, for bringing this project to fruition. Thank you. The second example that I want to share is on the criminal side. Some of you may know that Chief Justice Gantz commissioned a study of racial and ethnic disparities in our criminal justice system. Although it wasn't perfect, the study's main conclusions hold true. That is, that Black and Latinx people were less likely than white people to have their cases resolved through less severe dispositions, such as pretrial probation or continuances without a finding. And among those sentenced to incarceration, Black and Latinx people received longer sentences than their white counterparts. The report was published just days before Chief Justice Gantz's death, and he never had an opportunity to do anything in response to it. Early on in my tenure as chief, I spent a lot of time considering what I could do to further the work that Chief Justice Gantz had started in terms of reducing racial and ethnic disparities in sentencing. I previously had heard about the concept of restorative justice and knew that the legislature had provided for it in limited circumstances in the 2018 crime bill. But in talking to Judge Leo Sorokin, who sits on the Federal District Court here in Massachusetts, who was using restorative justice there, it occurred to me that restorative justice could play a role in reducing recidivism and sentencing disparities as a part of the criminal legal process in the state court system. I figured if the feds could do it, why not us? Now, it may be because I'm a mother of two boys, but I find the concept of restorative justice intriguing. That is, getting an offender to really think about and understand the harm he or she has caused so that they internalize it and make different choices going forward. Restorative justice has been defined as a process to involve, to the extent possible, those who have a stake in a specific offense and to collectively identify and address harms, needs, and obligations in order to heal and put things as right as possible. Typically, the people who have a stake in the offense are the person who committed it, the victim or related survivors, and the members of the community where the offense occurred. It's a voluntary process that brings these people together to discuss the impact of the offense and what the offender could do to make amends to the victim and the broader community. Ordinarily, this process takes place with people sitting in a circle, a practice rooted in indigenous traditions. In the circle, the offender, community members, and the victim or survivor, or in some cases a surrogate, come together to speak openly and honestly about the harm caused by the offense and how the offender can repair it. This process gives victims and survivors a chance to share the trauma and the grief that they've experienced and to shape the outcome of the case. And for that reason, victims and survivors who have participated in such a process often say that they find restorative justice more satisfying than traditional criminal prosecutions, where they so often don't have much of a say. The circle also gives the offenders the chance to understand the impact of what they have done and what they need to do to make reparations for it. Not surprisingly, because this process requires offenders to hold themselves accountable for the harm that they've caused, available data indicates that restorative justice has been remarkably effective in preventing recidivism. For example, the restorative justice program that's run out of the Federal District Court here, the data shows that participants were rearrested at a rate of about 17% compared to 30% in Massachusetts as a whole. Over the past several months, I, along with Other state court judges, some of whom are here tonight, have had the chance to participate in restorative justice circles run by the men at one of our state prisons. And I have to tell you that the experience has truly been extraordinary. The facilitators are trained to run the circles, and all the facilitators are serving time. Many of them are lifers. They provide a topic for discussion. For example, name a time when you felt safe, or name a time when you felt unsafe. And each person in the circle, whether he or she is a judge, prosecutor, victim, survivor, community member, or inmate, has an opportunity to share an experience of their own. The process sounds unremarkable, but by sitting in a circle as equals and sharing life experiences, we had the opportunity to see one another as individuals and as part of a broader community. Towards the end of the day, a few men who had volunteered ahead of time gave a public apology to a full auditorium. We, the audience, stood in for the victims or survivors as the offender described the crime that he had committed, the impact of the harm that he caused, and what he was doing to try to make amends. Giving a public apology is something that the volunteer had to spend a lot of time preparing for and working up the nerve to do. Having to face the hurt that one has caused is a difficult thing. The entire experience was exhausting, but very powerful and very meaningful. It gave me a chance to see restorative justice in action and gave me a sense of the potential difference it could make in our court system. Restorative justice is currently being used in a number of ways here in Massachusetts. In addition to the federal district court program that I mentioned earlier, several state district attorneys have been using restorative justice for pretrial diversion of selected criminal cases. We also have a statewide restorative justice advisory committee that was created by the legislature, as well as a number of nonprofit organizations that promote and support the use of restorative justice in schools, workplaces, and other settings. However, there's no program currently in place that incorporates restorative justice in criminal cases in the state court system once a defendant has been arraigned. So last year, I asked the justices of the SJC to appoint a committee that included judges, district attorneys, defense attorneys, and leaders of the probation service and its victim services unit to develop a pilot restorative justice program. That committee has now developed a protocol for the pilot program and has issued an RFP for community organizations to provide restorative justice services. Under the protocol, the defendant, prosecutor, and any named victims must agree to go the restorative justice route. The matter will then be referred to a community restorative justice provider for screening. If accepted by the provider, the case will be presented to the court to be accepted into the pilot program. Defendants who are accepted into the program will then participate in a series of circles with community members and victims or surrogate victims. Participation in the restorative justice program may also be coupled with other support services for the defendant, such as treatment and education programs. Defendants who successfully complete the restorative justice program may have their charges or sentences reduced. And in cases that meet the specific statutory requirements, the charges will be dismissed. If you're interested in finding out more about the pilot program, you can go to the SJC website at mass.gov. I expect that the program will launch later this year, both in Suffolk and Plymouth counties. And I'm enormously grateful to Suffolk County DA Kevin Hayden and Plymouth County DA Timothy Cruz for supporting the pilots in these jurisdictions. Thank you. So the program's going to run for 3 years, and if it's successful, we hope to expand it. Now, obviously, restorative justice will not be appropriate for every case, but in the right circumstances, it gives us a tool to better support victims and survivors, as well as criminal offenders, to reduce recidivism and hopefully to end the cycles of violence and revenge. I believe that restorative justice will show us that listening and collaboration can be just as critical to a fair and just outcome as the adversarial process. Which brings me to this year's Law Day theme. Don't worry, I'm winding down, not winding up. The theme, which you heard as Voices of Democracy, reminds us that exercising our voices as voters, as jurors, as lawyers, is essential to the success of our democratic system of government and our way of life. But speaking up and speaking out is helpful only if we're being heard. If we're speaking past one another, the message is lost. We must speak in a way that allows us to be heard and understood. And importantly, we also must be willing to listen to each other with open minds. I see this constantly in my work with my colleagues on the SJC. I think Justice Kafker can attest. When we first hear a case, we may not always agree on its proper resolution. But even when we disagree, we always respect each other's views. We really try to listen carefully to each other and look for areas of agreement. Most of the time, we're able to resolve our differences and reach a consensus. And I sincerely believe that even when we aren't able to reach a consensus, our opinions are stronger and better balanced as a result of the process. This is also true, I believe, of our legal system as a whole. We are stronger and more effective when we listen carefully to one another and seek consensus when we can. This is why input from bar associations and law schools, district attorneys and defense attorneys, corporate counsel and legal aid lawyers, and all the constituencies that compose our legal community are all so important to the success of our courts. And our efforts to listen to one another may point to a larger lesson. In many ways, the challenges that we face in our court system reflect the challenges that we face in our nation. People come to our courts from an extraordinary diversity of backgrounds. Many of them are dealing with enormous difficulties or devastating losses, and they often have what appear to be unresolvable disagreements. With your counsel and support, we seek to ensure that they are fairly heard and to reach resolutions that are reasonable, fair, and just. And to the extent that we can succeed doing that, perhaps we can show in some small way that the challenges we face as a nation are not insurmountable. Thank you.